Hello everyone. Good evening everyone. I'm live. So, okay. I'll wait for people to come through because I haven't really informed you when I'm going to be on live. I know I said after 8 and it's 8:18 now. So, I'll wait for a bit. I'll just kind of organize my video here. Okay, so just 1 second. Oh yes, 1 second. Okay, so I've got an audience. Just bear with me please, because I'm supposed to record this video on the other screen. So I've got this on my phone, and I've got on the side is my laptop. But I want to record this because okay, 1 second. Record to the cloud. All right. Okay. So this week it's been busy. I've been contacted by potential clients. I've been contacted by people who have been detained this week. It's not just one, but about 3 or 4 asking about what to do. Okay, so I've decided to get on live to explain what you have to do when you're detained and to stop, wasting money on lawyers. And this is because it's very depressing. It's a very depressing topic, and it's not my favorite topic at all. But I really just want to help because I know how desperate people can be when they get into detention, and so they contact lawyers and they pay. They basically throw money away on people. So just to let you know, for those people who don't know, my name is Annalisa Kerr. I'm an immigration lawyer. I help people get their visas to come and stay in the UK, renew their visas, but also help people stop getting deported. Although this area is not really my favorite practice, so because it's very stressful, and it's very it's depressing, and I feel so much guilty taking money from people, knowing that their families, they have to scrape money from families and friends. And that's why I'm here, because I want to make sure that before you do that, when you get detained, you have to be prepared for these consequences. And it's not fair on people, outside people, to to kind of make them feel guilty that they have to do something to help you get out. You need to also assess your case, whether you have a case, and you have to be realistic. So what I'm going to talk about tonight, this won't be a long video. It's just basically explaining, and for those who are affected, and for those who are overstayers, irregular migrants, or undocumented migrants. I won't call you illegal immigrants because I don't like that phrase. So, who are going to be detained? Okay, your options and what application can you make, and assess whether or not your case is strong enough to stop deportation. So, firstly, if you don't have visas, you've made an application, and you haven't got. Sorry, I just heard something. My husband. If you don't have visa, you've overstayed, you don't have pending application at the Home Office, you don't have pending appeal, then most likely you are a candidate for detention. Okay, if they find out where you are, if you are living with somebody who happens to be also an illegal immigrant. Sorry, I said I wouldn't use that word. Sorry, I do apologize. If you're living with someone who also don't have visa, then it's most likely that you will also be caught, because that's what happened with one of the people who contacted me recently. Okay, so someone came, knock on the door, and someone opened the door, not realizing who they were opening the door to. I mean, I would never open the door in London, or unless they have an appointment, then I open the door. But otherwise, don't open the door. So somebody knocked on the door. Apparently, she was very sleepy, still half asleep, and opened the door, and it was the immigration enforcer. So they came in looking for someone at that address with a picture, and apparently that woman doesn't live there anymore. And so, as you can imagine, so they didn't have visas, so they were caught. Okay, so most likely, if you are in those category, you will, it's just going to be a matter of time, because what they're doing now is they're actually knocking on doors now. Okay, so if you have an application, for example, that was refused 6 months ago, and you haven't done anything with your application, you haven't reapplied again, then most likely, if you're still at that address, they will probably knock on the door and come and get you. Okay, this is the theme that I've heard in practice now. So you are going to be detained. Also, if you have a reporting duty and you go and report, but you don't have any application, there's no pending appeal, no application with the Home Office, you just go there and report, please expect that they will, okay, that they will detain you. All right. What applications can you make? Okay, so please understand the difference between application to the Home Office and your appeal applications to the court. They're two different things. Application to the Home Office is your application for a visa. Okay, so you're actually applying, asking the Home Office to grant you the visa. Appeal and applications to the court, this is your application where you're asking an independent judge to look at your case and to check whether or not the Home Office who has refused you have made the correct decision, or whether the decision is lawful. And this is the difference. Okay. I had a client called me again this week from detention center, and she didn't understand what was happening. And she said that, oh, but I've got, I had application, and my lawyer didn't tell me that, my lawyer didn't tell me that it was refused. So I was, from her information from the information that she told me, I thought that she had an application with the Home Office. But it wasn't the case when I looked at her papers. It was that she was detained before, they were about to deport her, but she claimed asylum. When she claimed asylum, she then was released on bail while waiting for the asylum application to be decided. When it was decided, it was refused, naturally. If you come from, for example, Philippines, it's almost always you're going to be refused for asylum, okay? Almost always. I mean, I'm not saying it's 100% you'll be refused. It depends on the facts of the case. But because Philippines is considered as a kind of safe country, unless you can claim that and have evidence that your life is actually, you're actually being threatened, you have somebody is threatening to kill you, then you may be able to stay. But in most cases, it's difficult. So she's claimed asylum, it was refused. Then she appealed against that refusal. There's appeal hearing. And then the judge looking at the case also agreed with the Home Office and said that, well, she didn't really have, it was the right decision for the Home Office to refuse her asylum. Then her lawyer then appealed against the dismissal of the judge, because you can do that. You can do it twice, okay? But this notice of appeal to the upper courts only depends if your lawyer thinks, while looking at the decision from the court, from the judge, reasoning from the judge, that the judge has made a mistake, okay, or has not included all the facts, has applied the law wrongly. So only on those basis. Her lawyer then applied twice, but it was dismissed. The last time that the appeal, she sent notice of appeal, it was also dismissed, but her lawyer apparently didn't inform her. So she went to report, Okay, she went to report, and then that's when they arrested and detained her. So this is what I'm saying. Make sure you know when you report whether or not you have pending application. Liaise with your lawyers if you have a lawyer, and ask, have I got pending application? Okay, so if you don't, then ask what needs to be done. Okay, if your lawyer says the next thing, the only way that we can prevent you from being detained is to lodge an application. And you know that when you lodge an application, it's very expensive. It's 1,030 for home office fees. It's 500 immigration health surcharge plus lawyers fees. So you're talking about, for each application that you make, spend at least about 2,000, 2,500. Okay, altogether, just one application. So that's money in itself. So sorry, where was I? So yes, so know what applications, whether you have an application. If you don't have pending application, then most likely you get arrested. So when you get detained, you have two choices, and this is where you have to understand it, so that when you are there, you don't just call your friend, call your relatives, call your family partner, and and be desperate to get out, because they've changed the law now. In January, they've changed the law so that the Home Office have now really wide powers to detain, to deport people, and they're quite, from what I've heard this week, they're quite kind of aggressive. They're really doing it. Okay, so next Thursday, I'll be going on a conference talking specifically on the new law on detention and deportation. Okay, so I'll have more information about the new regulations, new powers that the Home Office has. So when you're in detention, you have two choices, and I think in my last video or a video before, I showed you how to complete those applications. One is, no, just the application for bail, actually, I did. So I showed you the forms for bail, okay? Application for bail is for your release, okay? So you can apply so you can be released, so you can be free. That is your application for bail. If you do it yourself, and I think there's another video that showed you how you can do it yourself. You can complete it yourself, okay? But only if you think you have a chance to be released. But in this new law, new regulations, the Home Office, you're not allowed to. You can't be bailed within 7 days from when you are detained. So you have to wait kind of 7 days. So that's application for bail, to be released, okay? That application does not stop your deportation, okay? So I just want to make it clear. When you instruct a lawyer, you say, I want to come out, I want to get out, and your lawyer say, okay, we'll apply for bail. It doesn't mean that your lawyer can stop your deportation, because that's not an application for stopping deportation. Even though your lawyer has made that application, the Home Office will still take you to the airport if your ticket has been booked. Okay, so a story as well. So a client this week, so she then got a ticket, but fortunately for her, I have already faxed a letter to the Home Office explaining that I am requesting her file from her previous lawyers, and that we will be challenging her deportation and her detention, and also that we've made application for bail. So this morning, and I'm glad I put my. I'm saying I'm glad. I'm sure it's not. It's not funny. It's not. It can't be nice for her, but at about 1:30 in the morning, because I woke up at about 3:30, 3 o'clock, and I saw my phone because I put it on silent. She called, okay, and she called and left a message, but I couldn't quite make out what she was trying to say. So I know that her flight was booked for 10 o'clock this morning, and yesterday I faxed her a copy of what I sent to the Home Office, a letter saying, you know, we are dealing with her case. So I called her again this morning at 8 o'clock just to check whether or not she's actually on the plane, and she called me back. So I said, okay, she's not on the plane, because usually if you calculate it, 10 o'clock, if your flight is at 10 o'clock, then usually like 2 hours you're already on the plane, and therefore if she had a phone they would probably confiscated it. So she called back, and I thought, oh, I'm glad she's not on that plane. So then she called me back. I'll try to call. We kept missing each other because I was walking and taking my child to school. So I called her, and I said, I even her partner called me and said, she's in the airport, she's been deported. And I said, no, she hasn't. She just called me like 20 minutes ago. She said, no, the phone, she already doesn't have the phone. I said, no, she just called me, but I missed it. And so she called me about half an hour later and explained that, yes, they canceled it, because she said, I'm not going. And because I'm challenging, my lawyer is dealing with this. And so she showed my letter to the Home Office, to the people who are, taking her to the airport. And they canceled it. So she wasn't deported this morning, which is good news. But the fact that we didn't have a court order stopping the deportation could have meant that she could have been on that plane. Okay, if she just kind of gave up and said, all right, okay, I really have no choice but to just follow, then yeah, she would have been on the plane now, okay, on the way to the Philippines. Right. So application for bail doesn't stop deportation. What stops deportation? The only application that will stop deportation is to apply to the upper tribunal for permission for judicial review, okay, and an application for urgent consideration. So urgent consideration means that the judge, when you submit to the application, the judge will look at it within 4 hours, okay, on the same day, and it has to be very urgent. And so the lawyer himself will take that application to the court, physically to the court, to lodge it. Okay, there's no time for posting it. Okay, you have to present the application. The lawyer has to present the application to the tribunal, pay the fee, and gather all the bits and pieces, the evidence, and come up with 3 copies, bundle of documents, 3 copies. Prepare all the reading materials for the judge. So it's, as you can see, it's very, very stressful for urgent consideration. This is not something that a lawyer can just, oh yeah, it's fine, we'll do it, It's not. It takes a lot of work, and that's why it's expensive. All right. So, okay. No, it's not the British Embassy. Sorry, I'm just reading a comment here. No, it's not a British Embassy. It's the government. Okay, it's the British government who will deport you. They will buy the ticket, but you can choose to apparently pay for your own ticket. And if you do, they will only ban you from coming back to the UK for 1 year. But if they deport you and there's a deportation order, then it means you are going to be banned for 10 years. So you won't be able to come back to the UK for 10 years. They will refuse. You can apply, but they will just refuse. Okay, so but it's the British government, not British Embassy or Philippine Embassy, no. Okay, so going back to application for permission for judicial review. Okay, so it's an application that, if it's very urgent, the lawyer herself will go to the upper tribunal to present and lodge this application. Now, it is an application to challenge, okay, to challenge the Home Office decision to deport you, all right, and whether it's lawful. because the Home Office is just a government department. Okay, so they can make decisions, but it doesn't mean that sometimes that decision may be wrong. They may not be applying the law. They may not be applying their own policy. They may not be considering the fact that you have family here, private life and family life, and you've lived here, and all those arguments, human rights arguments. Not human rights arguments normally will win. Okay, so that is the application to challenge, but before you can challenge it, you have to ask the permission. So that's why it's called application for permission for judicial review, the first stage. So you have to go to the court and ask the judge, ask the tribunal to give you permission to challenge that. So that is the first stage. And with that application is the urgent application, asking the judge to also make a court order to stop the Home Office from deporting you. Okay? In those cases, it's not I'm telling you, going back 2000 and 2011, it was really kind of judicial review. It was quite easy, and judges were quite liberal. They were obviously they were applying the law, but they weren't very strict. Okay, so recently, especially for the past few years, or maybe going back 5 years, when the law changed and it became difficult, the Home Office has introduced these new changes in the law. 2012, I think they started this. Then the courts have been very strict with, especially solicitors or whoever file for application for judicial review. You have to get it right. You can't just make an application with no grounds. Just cite the facts just to stop deportation, because that's what some lawyers do. That they accept the money and they say, yes, okay, we will make the application for you, but the judge will look at the application and it's just nothing there. There's no argument. Okay, and this is why I'm doing this, because I want you to understand that you can't just instruct your lawyer, because I know how desperate it is to be in detention, but you can't just throw money away. You have to also understand whether or not you have a case, whether or not when the judge looks at your application, is it strong enough? Do you have enough argument? Okay, so strong arguments will be, you have a partner here and you have proof that you've been living together. Okay, that he's ill, for example, and he needs looking after. You've been in a relationship for over 2 years. You basically just in partnership. You have a child here, for example. Those are the from the top of my head are the strong factors that you can use to win your case, to hopefully give the judge permission to challenge for judicial review. Okay, so one case I had that I remember, because I rarely do this judicial, I really do these applications. I do them, but and in some cases the Home Office in some cases the Home Office they don't really want the full hearing, because they have to pay for it if the client wins, and therefore midway when you submit the application they would just agree or go back to their decision, or reconsider their decision. Okay, but I had a case where we stopped deportation. So he was I think he was a unmarried partner of an EA citizen, and he was deported. He was already taken to the airport, and this is where our client called me at 4 o'clock in the morning. So if you're a lawyer if you're a lawyer specializing in this kind of area, deportation cases, you would expect to be woken up at 4 o'clock in the morning, 2 o'clock in the morning, because clients will call you. So client called me and said, oh, my partner is already in the airport. But before that, the day before, we got a court order stopping deportation. Okay, and that was because she had enough proof that they've been living together for over 2 years, and we provided that in the application. The other application that I had that was dismissed was kind of funny. Was from a woman. She was also an EA citizen, and she married an Indian. Okay, and I think this Indian had a lot of money. So basically, I think he probably paid her money to kind of marry her, and 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 then I don't know what happened. I think I don't know why they deported her. De, de, yeah, they arrested her and deported her. So her case was very weak. I was surprised that I wasn't criticized for the application because she insisted that I sent it, although it was really against my will because there was no evidence. So her story was they had an argument. The pictures, there's absolutely no evidence that they're in a relationship. The laptop was they were arguing on laptop. The laptop was stolen or the laptop was damaged and she couldn't retrieve the picture. Absolutely no argument. Absolutely no evidence that they living together. Just her word, which was not enough if you're a judge. A judge must see black and white evidence, and so it was rejected. Okay. So, wait a minute. Okay. Yes. So, yeah, I'm just reading a comment. So yes, from Nova. Yes, hi Joyce, hi Sol, hi Lit, hi Anna. Yes, from Nova. Yes, if you have a solicitor who doesn't explain to you properly, who hasn't obtained, you should just basically receive the money and abandon you. You can make a complaint to the legal ombudsman, okay, but complain to the solicitor first, and get them to resolve your complaint before you go to legal ombudsman. But yes, you can, which is what I've done with one case. Right. So going back to application for permission for judicial review, if you send that application, so and it's refused, you have, because the judge, the tribunal will look at the application only on the basis of the papers that you submitted. If the judge is not convinced enough on the papers, then you have a choice. Once it's refused, you have a choice to apply for your case to be heard orally. So then you instruct a barrister to go to the tribunal with the bundle of documents and argue your case in front of the judge, okay? And that's also very expensive. So, okay, so you're talking about £385 tribunal fee, and then the barrister's fee, and then the the lawyer's fees. So again, you're talking about another 2,000 to apply for oral hearing. I haven't mentioned the application for permission for judicial review, okay? So if you're instructing a lawyer to apply for urgent consideration, you're actually instructing your lawyer to drop everything that she's doing, all the other clients that she has, who also have urgent cases. You're asking her to drop all those, so therefore it's going to be expensive. Do not expect to get to phone a lawyer. You may find a lawyer who don't have clients, and you'll be very lucky, and who will do it for less amount. But normally in those cases, urgent consideration cases, emergency applications, because it is emergency application, then you have to expect to pay quite a bit. So for the application for urgent consideration, you're talking about maybe 2,000, 2,500. For the oral hearing, another 2,000, 1,500 maybe, for that specific argument. If that's refused, then that's it, okay? So application for permission for judicial review is refused. Oral hearing application arguing your case is refused. You can appeal against that, okay? So there will be a court of appeal, but then you have to ask permission. Okay, so if you really take your case all the way up to Supreme Court, it will cost you money. All right, so while all these hearings going on in the court, you can then ask for bail. Okay, so in those cases, it's most likely you will be released while you're waiting for the outcome of your hearing. Okay, so that's the application for judicial review. And there's the appeal against the if you can afford it. If money is not an issue, then yes, by all means, pay your lawyer to take it up all the way. If you think you have strong arguments, you need to get out because you have a partner. You've been together for many years. And then yes, you can do it. That's your choice. Okay, so is your case strong enough, okay, to stop deportation? Think about it. If you've been in this country for, let's say, 3 years, 5 years, and you don't have any links, okay, and for example, you came here illegally as well. You didn't have visa, or you used someone's identity, for example, or you came here via a boat, and then didn't get a visa. They didn't have any records of you ever coming to the UK. Then, and you don't have any relationship, you don't have any boyfriend, you don't have any girlfriend, you don't have any partner, you don't have any children, just you, but less than 10 years, most likely your case is not strong enough. Okay, so the judge will look at it and say, well, what are your links? What are you arguing? What are you arguing? But if, for example, you've been in this country, you're quite active in your community, you volunteered, you help out, raising money for charity, involved in a specific club. If you can show that you're actually active and integrated within the British community, and you have evidence to support that, for example, you have statements from the say club members or community members, church members, priests, confirming your involvement and your help in the community throughout the period that you've lived here in the UK, let's say 9 years, then yes, it's arguable. But if you're just here 3 years, 4 years, 5 years, and all you've ever done is work, okay? Because I know it's not. You're not supposed to work. Everybody knows that, but everybody knows as well that to survive you have to work. Okay, if that's all you've been doing, and then you get found out, taken to the detention center, then I don't really think it's strong enough for you to argue that you should remain in the UK. So if you're in that category, so assess your case. If you're in that category, then don't waste any money on lawyers. Okay, if you can afford it, if you want to, then go ahead, but think about it. The money that you would spend, let's say 6,000, 7,000 for lawyers fees, what could you use if you actually go back to your home country? Maybe you could set up a business or invest it and make more money, instead of actually giving it to the lawyer, and then you come at the end of it, you go home without anything. Maybe you have debts as well because you've borrowed money from, friends, from relatives, to pay for the lawyer's fees when deep down inside you don't really have a case. Okay, so that really is all about. That's all I wanted to talk about. You see, I get very passionate about these things because I find it quite frustrating to explain to clients that your case is not really strong enough. There was one as well, one again recently, who inquired, and she's been here I think 4 years, and she got taken, she got arrested, and her employer, she doesn't have anybody anybody in the UK. She was just working, and her employer was willing to, help her. But there is no other option for her. She can't apply for, you know, as a work permit. She can't apply for work permit. There's no, there's nothing. So I said to her, look, there's no, you'll be wasting money, and you can try and argue, but there isn't really argument, and it's difficult for lawyer as well to come up with argument. We can't make these things up. I had one, and it's an appeal, and and I have to forward an appeal, and to scrape facts that I can use in order to send the application to the tribunal, to include it on the grounds of appeal is difficult if there's not much to it. Okay, so it's difficult for lawyer as well to get this, to get the correct facts, to arguable facts to use to convince the judge that there is a case. All right. Are there any questions, people? Let me just check and see if I haven't missed anything, because I've got my notes here on my computer. Right. Okay, going back to who can be detained. If you're applying for judicial review, for example, okay, and if you're applying for judicial review, technically, if you haven't got a court order stopping deportation, technically the Home Office can still deport you. Okay, so so they can still deport you, even though you have a pending judicial review application. But the reason why they won't deport you, it's because if they get it wrong, okay, if the judge looking at it is agrees with your argument, then it means they have to actually pay you to come back to the UK and pay you compensation. And they don't want to do that because it's expensive. So it's better that they keep you here while there's application for permission for judicial, application for judicial review. But technically, they can still deport you because there's no court order. If there's no court order stopping deportation, then they can deport you. So one question: how about if you come to UK as a student, then you overstayed? Yeah, it's still the same, I'm afraid. The difference between somebody coming here and overstaying, coming here with a visa and overstaying, and somebody coming here without a visa, because apparently this is possible, and yeah, it is possible in especially Eastern Europeans. The difference is when you then make an application, the Home Office uses this against you. Okay, so they won't use that against you that you've overstayed, because they already have that on their system. You've overstayed. Okay, but if you come here, if you came to the UK without a visa, they will think that you're dishonest, you're not credible, you don't have good character, and they will use that to refuse or to argue. If there's a hearing, they will use it to convince the judge that this person, we can't give this person a visa because this is what he did. He came here without any regard for British immigration law, came here without a visa, or using false ID and so on. So yeah, it will be used against you. But even with that, and you have good argument, like you have a partner, you've been living with them for over 2 years, and you can prove it, then and the judge agrees that the relationship is genuine, then even though you came here without a visa, that private life, family life, human rights argument will win. Okay, but if there isn't anything like that, then yeah, they will say, well, you haven't got, you're a very bad person, basically. So yeah. Okay. Any question, guys? Hi, hi, Marianne. Sorry, I was going to read your Yes, if a person found a British guy, not just a British guy, but someone settled, okay, someone with indefinite leave to remain, and they've been going out together for over 2 years. It's over 2 years. It's 2 years. If it's less than 2 years, then it's difficult to argue. Okay, there may be argument if you have a child with a person, even though you haven't been living together for 2 years. But if it's less than 2 years and no children involved, there are no children with a settled person or British passport holder and living together, yes, that's yes. Normally they won't deport you. Okay, they will let you. They will take that into account. And I have had many clients, having a relationship, even though they've overstayed and they're still here. Okay, but you have to provide proof. You can't just say, yeah, we've lived together. So proof would be independent proof. So although you can't, in most cases, if you've overstayed, you probably don't have documents. You can't have, bills in your name or council tax or bank statements. If you have, let's say, 2 or 3 independent people confirming that, yes, I know these people to be a couple, for I've known them for over 2 years now, and so on, then yes, it's that will really help the application, or as evidence that the relationship is genuine for over 2 years. Yes. Okay, so right, I think that's it. So it's 9 o'clock, and I have to check on my daughter because I think she needs to she needs to go to sleep. Yes, you can. Yes, it's fine. If a person came here with a tourist visa and have a baby with the British guy, yes, you can use that. You can use that argument to be able to stay. Okay. I did have client who came here. It doesn't matter whether a student or tourist visa, because they came here as with a visa. And she had a baby. She had a baby. She was refused once, and then we reapply again, and with the baby, proof that they have a baby. Then she had a visa. Yes. So what I would suggest is, for those who are overstayers but have formed relationship with a British person, settled person, and they have a child. Remember that child is entitled to British passport. Okay, automatic. So ask your partner to apply for British passport, so that you can then make an application on the basis that you have a child who is British, but also you have a partner who's also British. Then you've got, it makes it much stronger case. All right, guys. So if you have any other questions, please PM me or leave a message on this video. I've gone on quite long now. So thanks very much for watching. I hope it's been useful, and please don't waste too much money on lawyers. Okay. Have a good evening, everyone. Bye bye.